Hi, my name is Michael Gilfix of Gilfix and Lopole Associates. I'm going to take just a couple of minutes and talk about one of the major issues that is of likely concern to you. It's the cost of long-term care. It's an issue that comes up in countless family situations. There might be a diagnosis, dementia of the Alzheimer's type, some other nature. There might be some event, a stroke, something that has caused a lot of worry, and again, the probable need for long-term care services. And the question becomes, how do you pay for it? So in summary, there's four ways in which you can pay for the cost of care. Out of your own pocket, $7,000 to $10,000 a month. It's devastating. Long-term care insurance, if you happen to have it. If you're facing this issue and you don't already have this insurance, you're not going to get it. Medicare, very rare is the situation where Medicare pays more than maybe a couple of months. So it's not a long-term solution. So it really comes down to Medi-Cal, which is California's version of the federal Medicaid program. Eligibility basically depends on how many assets you have if you're in a long-term care setting. If you're a single person, can't have more than $2,000 in countable assets. Some assets don't count. Some assets are exempt, which means they're invisible for purposes of establishing eligibility. The most significant exempt asset is your residence. Under today's law, the residence can be of any value and it doesn't count. It could be $2–3 million residence and it doesn't count. That's going to change. That's why I emphasize today. Okay, so it's exempt, but to really emphasize, the residence might be exempt and not count when you're determining eligibility, but if you receive Medi-Cal benefits and you own it or an interest in it, or it's in your living trust at the time of your passing, the state will assert a claim to get its money back, which so often forces the sale of the home, the loss of the home. So it isn't enough to just say it's exempt. We need to plan to make sure that we protect the house. Okay? So if you're a married couple, there's a lot of protections for the spouse who's living at home. While the spouse in the nursing home, again, can't have more than $2,000, there are asset protections for the spouse who's living at home. Under today's law, the rule is that, let's say the wife is living at home. The wife can have at least $113,640 in her name at the time that her husband qualifies for Medi-Cal. There are income protections. It's a little over $2,800 a month that the spouse living at home is virtually guaranteed, often higher. We can get a court order in some cases, go to what's called an administrative hearing to increase the amount of income available to the spouse who's living at home. So the whole point is you can plan. It's not a matter of just letting these events happen to you. The law is very forgiving, it's very flexible. It's a matter of knowing what the law is. And let me emphasize, I have worked on this issue. It's an amazing concept. For about 40 years, after I graduated from the Stanford Law School, I created the first free legal services program for elders in the country. And it was in 1973 that I did that. And early on, we started dealing with the cost of long-term care. So I've watched the Medi-Cal program evolve. I've been writing and lecturing about it, for 40 years. I mean, it really is kind of an amazing concept. And I bring the benefit of that experience to all of the attorneys who work in the office. So for you, it's a matter of deciding, are you going to be proactive? Are you going to take steps to protect your assets, to make sure that your loved one, that the person in need of long-term care gets quality of care, again, while protecting assets. So we have many goals we want to achieve. We want to be sure, above all, there's quality of care and options for the person in need of care. In most situations, that person wants to protect assets. And particularly that's the case with regard to the residents. We can do it. Now, last comment is that the law is going to change. We have something called the Deficit Reduction Act of 2005. It hasn't been implemented in California yet. It is about to be implemented. So at some point in the year 2013, we expect the rules to change significantly. So if you want to do your planning before those rules are implemented, because they're going to tighten things up. We can protect the estate, virtually the entire estate under current law. It's just a matter of looking at the many options that present themselves. Many, many, many options. It's a matter of figuring out the plan that makes sense for you. when we have this responsibility, we are also responsible, in most cases, for doing the Medi-Cal application. So we really take over and take care of it. I'm very pleased to share this information with you. It is an invitation to take advantage of our services. I assure you we'll take excellent care of you and give you the solutions that you need.